Hello, my name is Rhiannon from Bristol Vehicles for Change, and today we'll be talking about the police, crime, sentencing and court bit. So I'm here today with Marc QC, who is the leading authority in this area of law. So, a person found guilty of a criminal offence under the bill will be subject to a range of new powers available to the court. These powers will include the destruction of the resident's vehicle. It will also include up to a £2,500 fine and even up to 3 months in prison. So Marc, can you please tell us, who does this law impact? So the wording implies that it applies to people residing in vehicles. How does one establish whether someone is residing in a vehicle or not?
Well, if I can just unpick that question and begin with the likely subjects of the legislation. This legislation is likely to impact on Romany gypsies, on Irish travellers, on new travellers, and also anyone else who lives and travels around in a vehicle, whether that be in a van or a bus or in a vehicle carrying or pulling a caravan. And as far as the question that you posed about residing in the vehicle is concerned, the point is that it will be up to the police officer who ultimately decides whether or not to arrest as to whether or not they think that the individual is residing in the vehicle. And residing can, I think, include somebody who is perhaps even travelling on a holiday in a camper van. The point being, it doesn't have to be a permanent residence. It doesn't have to be used as a permanent residence. A van or a caravan can be used on a temporary basis and still fall within the provisions.
Okay, thank you. And what is legally defined as a vehicle under this new act? And does that also include what is defined as a caravan under the Caravan Sites and Control and Development Act as well? So a vehicle in section 60C subsection 8 of the Police, Crime, Sentencing and Courts Act refers to any vehicle, whether or not it is in a fit state for use on roads, and includes any chassis or body, with or without wheels, appearing to have formed part of such a vehicle, and any load carried by and anything attached to such a vehicle. So that's the definition of a vehicle. And the definition of a caravan, so that's defined in section 29, subsection 1 of the Caravan Sites and Control of Development Act of 1960. So that includes, or that means, any structure designed or adapted for human habitation, which is capable of being moved from one place to another, whether by being towed or being transported on a motor vehicle or trailer, and any motor vehicle so designed or adapted, but does not include any railway rolling stock, which is for the time being on rails forming part of a railway system, or any tent as well. So what does that mean, Marc?
Well, in practical terms, we're talking about a van or a bus that is used for residential purposes, or a camper van perhaps, or alternatively a caravan, the thought that you would see being towed along by maybe a transit van or a vehicle. It would also include a static caravan. It clearly doesn't include railway carriages, but you're not likely to see those parked up on the side of the road. It's pretty much all encompassing, and it doesn't matter whether or not the vehicle is in a fit state to drive along the road for it to be covered by the legislation.
So what do we mean by the criminalisation of trespass? What new powers does this act give landowners in order to deal with trespassers?
Well, trespass has always been considered to be a civil matter, although in fact successive pieces of legislation have criminalised trespass in different ways. So back in 1994, the Criminal Justice and Public Order Act brought in powers which were given to the police and local authorities, draconian powers, to move on gypsies and travellers and others parked on private and public land on pain of being arrested and being prosecuted. So to some extent, trespass has been criminalised for at least 16 years, I think it is now. My math might be wrong on that, but the reality is that these powers under the Act are adding to those, and they're much more egregious and much more let me put it this way, they have a much greater impact on the ability of gypsies and travellers and others living in vehicles to live in accordance with that way of life. They will give landowners the ability to ask people to leave if they're parked on their land, and if they refuse to do so, or don't comply with that request within a reasonable period of time, a police officer will be able to arrest the individual, seize their caravan or their vehicle that they're currently residing in, and potentially keep that vehicle and ask a court to forfeit that vehicle if ultimately the case goes to trial.
So this act allows for a lot of speculation about a person's intentions or personal circumstances. So, for example, Section 60C uses terminology such as disruption likely to be caused by the person residing in a vehicle. Will the courts be evaluating the evidence in each particular case?
Well, the point about this provision in the Act is that it can be an offence can be committed where there is a likelihood of damage, a likelihood of disruption, and a likelihood of distress being caused. And those are very subjective elements. And it's going to be really easy, I think, for a landowner or indeed a police officer to conclude that an individual camping on private or public land without consent is likely to cause damage, disruption or distress by virtue of them being on the land, or potentially by virtue of their conduct. And unfortunately, what will play into that determination, that decision-making process, is likely to be, using the wording in the Act, prejudices against gypsies and travellers and others who live in vehicles. And I'm afraid that it means that it's very likely, again using the same word from the Act, that the police will use these powers and will use them much more regularly than they use the powers under the Criminal Justice and Public Order Act. And the question you ask is, well, would the court step in and perhaps, having heard the evidence, conclude that there isn't a likelihood that damage, disruption or distress would be likely to be caused? And I think there is every chance that the court would step in if there were ever a trial. But the problem with the Act and these provisions is they are so draconian in terms of the punishment that can be meted out if there is a conviction, with homes being seized and possibly forfeited, and a prosecution leading to imprisonment for up to 3 months. That many people, when asked to leave, indeed threatened with arrest, will simply get up and go, whether or not there was any real likelihood that they would cause damage, disruption or distress. So it will have a chilling effect.
Thank you. So it could lead to a lot of displacement.
Exactly. We'll be chasing gypsies and travellers and others living in vehicles from pillar to post, hounding them, really. And I think, unfortunately, that is part and parcel of the raison d'etre, the reason behind the legislation to hound gypsies and travellers and others off the road.
Section 60C, subsection 6, creates a defence to present a reasonable excuse. So that could be for failing to leave the land or re-entering the land. What does that mean?
Well, we don't know precisely what it means, and it will depend very much on the police officer on the ground, and his or her view of the circumstances. It will depend also on what information the police officers are given about the circumstances of the individual who is being threatened with arrest. So an individual may be able to say, well, I've got a medical emergency, or I need to be here because my husband or my wife is in hospital just down the road and there's nowhere else for us to park. That might be considered, and ought in my view, but certainly might well be considered to be a reasonable excuse. There is draft guidance that has been issued by the government, which goes with this legislation, which suggests that a vehicle breakdown would not be a reasonable excuse, and other appointments that might be needed to be kept would not necessarily be give rise to a reasonable excuse. But I think a medical emergency certainly would. But we'll have to wait and see, and it will depend very much on the decision maker, the officer in the case.
So we might see quite a lot of variation on the ground and how this plays out.
Yeah, but ultimately, if the officer says that isn't a reasonable excuse and I'm going to arrest you, well, again, the chilling effect is all too present. And whether or not there is a medical emergency, it may be that people will simply, notwithstanding their ill health or the ill health of a relative, perhaps, get up and leave.
So what about existing enforcement measures? So borough-wide injunctions and public space protection orders have been very common in recent years. Does this new law not make all of these efforts pointless?
Well, there are many different ways of enforcing against unauthorised encampments, which is what we're really talking about here. And as I said earlier, in the Criminal Justice and Public Order Act, we have already draconian measures and powers which the police and local authorities can use to move gypsies and travellers and others in vehicles on from land where they're camped without permission. On top of that, we've had a recent what's been called a feeding frenzy of local authorities seeking and obtaining borough-wide injunctions. And that feeding frenzy, thankfully, was brought to a shuddering halt in a case involving Bromley Borough Council, where the Court of Appeal noted that the local authorities resorting to using these wide injunctions had become, in vogue, very fashionable. But in fact, they should be granted very sparingly, if at all, and impose quite strict conditions as to when they should be imposed. And so borough-wide injunctions are not necessarily a thing of the past, but are going to be much more difficult for local authorities to obtain. As far as public spaces protection orders, or PSPOs, is concerned, I don't think they have been used very often by local authorities against gypsies and travellers and others living in caravans, but that might be just my experience. And I don't think they're particularly effective. And they can also be subject to challenge by anyone who considers that they ought not to be imposed, or that they ought not to cover a particular type of conduct. And the thing about asking or a local authority to use its powers to create a public spaces protection order is that they're designed to tackle antisocial behaviour. And one cannot, in my view, describe a way of life, living in caravans or vehicles, as antisocial per se. There may be elements of a community who commit antisocial behaviour whilst they are living that way of life, but those people can be dealt with, and their conduct can be dealt with using antisocial behaviour orders, or alternatively criminal sanctions can be imposed.
Yes, antisocial behaviour can be found in any part of society,
exactly.
Can't it? Yes.
Yeah.
And when considering the Equality Act and the Human Rights Convention, is this act lawful?
Well, the Act itself has many elements, but the part 4 of the Act, which deals with these what I would say egregious powers, is going to be subject to challenge, I'm sure, by gypsies and travellers and others affected by it. I mean, just as an example, you asked earlier on who it would cover, but it would also cover protest camps. Those using or exercising their right to protest, but living on a piece of land in order to do so. If they're living in a vehicle, whatever that vehicle might be, caravan or otherwise, they will also be subject to the possibility of arrest and forfeiture of their vehicles and imprisonment. So, going back to the question of whether or not it's lawful, there may be challenges brought by gypsies, travellers and others living in vehicles, and also those who want to exercise their right of protest, and by doing so set up a protest camp. Is it lawful? I would say no, categorically. And it seems to me that the most impactful element of the new legislation is this. It seems to me that the Act, and particularly this part of the Act, can be challenged by most effectively by Romany gypsies and Irish travellers. And the reason for that is that they are ethnic minority groups recognised under the equality legislation in the UK. And the European Court of Human Rights has also recognised that those groups have a traditional way of life which is deserving of respect under Article 8 of the European Convention on Human Rights. An integral part of their traditional way of life is living in caravans. Now, the problem is in the UK that we don't have enough sites, lawful sites, on which Romany gypsies and Irish travellers, or indeed any form of traveller, can live. And so many are forced to continue living their traditional way of life in caravans, but on the roadside or occupying unauthorised encampments. So until there is sufficient site provision for ethnic gypsies and travellers, they will be caught between a rock and a hard place when a police officer comes to exercise these powers under the Act. And that seems to me to have a disproportionate effect on them. And they will be able to argue that the Act discriminates against them in an indirect way, but in a very effective way, and forces them, in effect, to choose between a life continually on the road, moving continuously on pain of being arrested and their homes being seized, or alternatively being forced into housing, which is not a form of accommodation which is suitable to them and is not in accordance with their traditional way of life. So I think there'll be a challenge by Romany gypsies or Irish travellers first and foremost, but there may be others who will also want to challenge the legislation.
And what about non-ethnic vehicle residents? Could the public sector equality duty perhaps be called upon here?
Not the public sector equality duty, because that in essence is looking at equality between different ethnic groups, and so non-ethnic travellers, new travellers, for example, vehicle dwellers and the like, wouldn't be able to rely on the public sector equality duty, but they would potentially be able to bring a case under the European Convention on Human Rights, relying on Article 8 of the Convention, which protects the right to or provides that one should have respect for one's home and family life. And the home might be the van or the bus or the vehicle, and also based upon Article 14 of the Convention, which protects one, or at least ensures that one is entitled to enjoy the other rights of the Convention without discrimination. And discrimination in that sense isn't limited to race or ethnicity. It can include a phrase known as other status, and that can include, in my view, a way of life that one has decided to take, and that, you know, living on the roadside or in vehicles could encompass that. So I think that, for example, new travellers could say, well, we may not have ethnicity which is protected by the UK equality legislation, but we do have a way of life which is different from others, and this legislation will impact us much more disproportionately than it will, for example, those travelling up and down England in a camper van on their holidays.
So do you think that argument would be particularly strong for a new traveller who had grown up living that way?
Yeah, I think the longer that a new traveller has lived in vehicles, and perhaps the stronger their aversion to living in bricks and mortar, the better the argument might be for them. But I think the vanguard, or the forefront of the challenges, you'll find that the strongest cases are going to be those brought by ethnic groups, because they'll be able to rely on their ethnicity.
That's really useful to know. Thank you.
Good.
And kind of going back to what you mentioned earlier, will local authorities be able to balance or counteract this national policy with local policies such as negotiated stopping or site provision, like you mentioned earlier?
Yes, they will, and they ought to. It won't have a mitigating effect, in my view, which would render this act and this provision lawful. But given how draconian it is, and indeed how unnecessary it is for this provision to be brought in, this legislation. I mean, bearing in mind that the police were asked in consultation about these provisions, and they said we don't want them. there's no need for them. We've got sufficient powers already to deal with unauthorised encampments. And indeed, the police also indicated to Parliament that they thought that this legislation breached the Equality Act and the Human Rights Act. So it's worthwhile remembering that. So it's that bad. It's going to have that bad an effect on those living an alternative lifestyle that we really ought to respect. That I think local authorities should do everything in their power to try and mitigate its effect. And they won't be the ones, as it were, on the coalface or on the roadside when the police are deciding whether or not to arrest. It could be that the police are quite happy to arrest whether or not there is an alternative place for the individuals, the families living in perhaps a caravan or a van can go to. And so I think local authorities will need to play a part, first of all, in terms of trying to make sure that they work in partnership with the police, so that if ever the police are called out by a landowner and asked to exercise these powers, the local authority is there to assess the welfare needs of the individuals or the families concerned. Secondly, that they're there in a position where they can say, look, rather than arrest, let's take a more measured approach and offer the family or the individuals an alternative place, perhaps a place which comes within a policy known as the negotiated stopping policy, which a number of local authorities are looking at developing. And thirdly, I think they ought to be there as a mediator, because ultimately, if homes are seized, caravans, vans, and the like are seized, children will be rendered homeless, particularly for families involved, and the social services may have to get involved anyway, and that's the last thing anybody needs or wants. And so it seems to me that local authorities ought to mediate in those circumstances, and that would be the best for everybody. If ever there's a situation where this new power is going to be invoked.
Thank you. And as a final question, where can people get support and legal advice if they are faced with any of the issues that we've just mentioned?
Well, I think the first port of call would be an NGO, a non-governmental organisation, an organisation that works with gypsies and travellers and other people who live in vehicles and vans. My first thought is Friends, Families and Travellers, an organisation based down in Brighton. There's an organisation called Traveller Movement based in London, and another in London called London Gypsies and Travellers. There are other local organisations, and I know that there's an organisation in Bristol, Vehicles for Change, I believe it's called, so that's another. In addition, there are solicitors who work with gypsies and travellers who are expert in this field. They are very few and far between. There's a bit of an advice desert. The firms are accessible through the NGOs, and they're also sometimes noted on a publication known as Traveller Times, which is accessible on the web. And on top of that, there are other organisations that assist with gypsies and travellers and others living in vehicles, like the Citizens Advice Bureau. And then you have publications like a book, which I wrote with others, called Gypsy and Traveller Law. The third edition was published in 2020, and by an organisation called the Legal Action Group. And the Legal Action Group every 6 months publishes a magazine update of the law on as it relates to gypsies and travellers and others living in vehicles. So there are different sources which one can kind of mine, on the internet. But there are also advice lines, and there are specialist solicitors who, if you can get in touch with them, will assist. But at the moment, we're in somewhat uncharted territory, because nobody at the point that we're having this discussion has yet been arrested using this new provision in the Act. And we haven't yet seen what the judges might think of the legality of this legislation. You can only hope that they agree that it is unlawful and ought to be struck down.
Thank you, Marc. So we'll see how this unravels then. Well, thank you very much, Mark.
Sure.
And thank you everybody for watching. We will be providing the links for those NGOs and also for Mark's book as well. So thank you all for watching, and thank you, Mark.
Thank you.